Now, the Supreme Court of Appeal has granted Dr Nandipha Magudumana leave to appeal by decision appellate decision by the Bloemfontein High Court, which dismissed her application to declare her repatriation from Tanzania unlawful. Although the High Court found that her deportation was disguised extradition, it ruled that she had consented to returning to South Africa. Let's unpack this further as we are joined by legal analyst Mpumelelo Zikalala. Mpumelelo, good evening, and thank you so much for joining us.
Good evening to you, and also good evening to your viewers.
Right. So basically, in the simplest terms, what does this mean that leave to appeal has been granted?
It simply means that the SCA has said, Dr. Magudumana, we believe that you may have a case. We're not going to close the door on you. You have a right to access our courts. So we are inviting you to come and make representations or make submissions pertaining to your matter. Come and convince us once again, in addition to the paper that you have submitted, to say that, well, there was deportation that took place and whether that particular act is inconsistent with the Constitution. If that's the case, then we may allow you to rule that your arrest must be ruled as one which is inconsistent with our laws. Hence, there may be a chance that you may be let free. But she may have a few problems with regard to that particular act. If you look at what Section 172 actually says, it gives the power, the court, the following powers. It says, yes, rule that your conduct is inconsistent with the Constitution. However, you can either limit the retrospectiveness of the inconsistency which has taken place or make any other appropriate provision that is there. Now, let's look at the facts of this case. The court would be very uncomfortable in arriving at a situation in which another court is still dealing with the merits of the matter. They are a prima facie evidence that the person that you are dealing with may be indeed guilty of a particular crime, and you're simply going to let them go scot-free if there's a technical blunder that has taken place on behalf of the South African government. That is above the hurdle, or let alone the hurdle that she still has to prove that at the end of the day, the state may come back and say there was a deportation that took place. All that we did was to facilitate the transportation from Tanzania and over to South Africa, and once we landed in South Africa, and that's when we effected the arrest.
Well, I mean, earlier in the year, the High Court ruled that Magudumana consented to returning to South Africa during Thabo Besta's arrest in April. I mean, does that change the dynamics of the case in that regard, or is it just about, as you've just touched on, the technicalities thereof?
If that particular sort of line or ruling actually stands, then it says, even if you want to declare the particular conduct inconsistent with the Constitution, the court has a discretionary powers in terms of choosing. What then do you do because the act or conduct is inconsistent with the Constitution? Either you're going to say, I'm going to reverse back the inconsistency and make sure that I regularize or correct whatever conduct that was there, or I'm going to say, I'm going to disregard and give you an appropriate order in line with the intention of what the intended purpose was. Hence why I was stating earlier that if there's a technical blunder that has taken place, the court's not going to simply say, this is an inconsistent act, you are ruling it away, you must be let out, that's the end of the story. The court is going to say, let's look into this whole matter holistically. Let's look at why the police were there, any other affected individuals that are there, and let's make an order which is going to be appropriate in these circumstances. And the other step or the other matter in which they're going to look at, they're going to say, there's a criminal matter which is currently taking place. If you are worried about you being let free, go and apply for bail. If bail has been denied, go and make sure that you are able to submit that particular appeal. However, there's still a process which is going to determine the innocence or guilt in terms of this particular conduct. So it's not going to be easy as maybe it might be anticipated by other individuals. Another point which is also important to mention is that even if these whole proceedings go the manner or the way in which Dr. Magudumana wants them to go in, it's not going to whisk away the type of charges which are going to be there. She can be arrested the minute she walks out of court on all the other charges that are there because she hasn't pleaded as yet inside court, so there are no proceedings that have started. If the pleading stage has started, then it basically meant that she can't come back again and declare that it's a double jeopardy type of proceedings. So in this case, one wonders as to the real intention behind this type of applications when they're not going to yield the results of you being spot-free.
And you touched on the issue that there is currently a case that is underway. Does that then, or how does it affect this other one, or are these two different cases, as it were?
There are two different cases in terms of them being adjudicated. So the other one would run its course, and the legal principles applying to that one would be there, mainly the Criminal Procedure Act. However, when it comes to this one, where the leave to appeal has been granted, that may be taken as a factor if this particular conduct of the arrest is declared inconsistent. Because one of the submissions that can be made, or the consideration that can be made by the court, would be to say, we are using our powers and our discretion is empowered by the Constitution to replace the inconsistent conduct with the conduct which is inconsistent with the Constitution with the appropriate relief, taking into account the type of rights that are accrued to you, the type of, or the harm that you are trying to prevent in all of this. Because what the court can't whisk away, or what the court can't ignore, is that there are a number of individuals that are affected by this type of litigation. It is not only Dr. Magudumana at the stage. You have him, you have the various departments that are there, but most importantly also the victims, that even though they're not directly involved in this particular litigation, they are still a factor that has to be considered at the end of the day. So it's one of those processes in which the court will have to take a calculated move and apply its discretionary purpose, with the eyes of saying that we want to make sure that the rule of law is the rule of law. And in instances where there's been non-compliance, for example, let's look at the graveness or whether that non-compliance is so detrimental to the whole matter that a person must be let go. If the answer is no to that, then the court is going to apply the appropriate relief.
Looking at the facts that we have at our disposal now, and I mean, it's not much, as you did say that the case is still unfolding in both directions, but what are prospects of success, if any, based on the information at our disposal?
I would put my head on the block and say they are very limited. And even if there is success, for example, I would think that you would want to engage in this type of litigation if you are going to be left scot-free and they're not going to be arrested, they're not going to be a free individual. In this case, you're not going to get that. So there is no verdict which is going to say, Dr. Magudumana, you are declared not guilty in all other matters that you are facing, so we are letting you go. It would be simply a system of saying this, yes, your arrest was inconsistent with our constitutional provisions that are there, but it does not mean that the merits of why you were arrested must then be ignored. You can still be rearrested again and be able to deal with the matters at that particular point in time. So it's not going to give you the ultimate price. And secondly, why I say the prospects are a bit slim, the very same provisions which is relying on then empowers the court to sort of do a system of self-correction and to say, yes, there is inconsistency that has taken place. Despite the inconsistency taking place, let's apply or give out a ruling which is going to remedy that particular inconsistency. But we're not going to do that blindly as a court. We're going to make sure that we're able to protect whatever provisions and rights which are put to you as an individual. Remember, you are still innocent at this particular stage, as a position that says. But there are remedies and avenues which are available. For example, applying for bail that you can go and apply for. There is another remedy when the actual trial starts, in which we then go and highlight instances in which your rights have been infringed so that you don't have a fair trial. And based on those, you can get the ultimate prize, which is the acquittal. But for now, we are going to take a calculated decision of saying that we are protecting the rights of all the other individuals that are there, right, including your one with alternatives, and saying to you, this is what you can do in order to be free.
All right, Mpumelelo Zikalala, thank you so much for taking time to speak to us. Legal analyst Mpumelelo Zikalala, as we try and unpack and understand the situation at hand with Dr. Magudumana given leave to appeal.